Welcome back to the deep dive. We are continuing our journey through the MPEP, the Manual of Patent Examining Procedure, still in Chapter 1400, Correction of Patents.
That's right. We're talking about reissue applications when you need to fix an error in an issued patent. And today, we're hitting MPP Section 1418.
Section 1418, Notification of prior concurrent proceedings and decisions thereon, and of information known to be material to patentability. Wow, that's a mouthful.
It is, but it's absolutely crucial. Think of it as the rule that enforces transparency during the whole reissue process. It's about making sure the Patent Office knows the full story of the patent being corrected.
The full story. Okay, so it's not just about the technical fix you're trying to make.
Not at all. The main idea here is preventing information silos. The applicant, the patent owner, has to basically lay all the cards on the table about the patent's legal history and any relevant technical info.
Right, so the USPTO isn't examining this correction in, like, a bubble. They need the context.
Precisely. Especially if this patent has already been through the ringer in court or, other USPTO proceedings.
Okay, let's break that down. The first part seems to be about prior concurrent proceedings. What exactly does the applicant need to tell the office?
This is a big one. It's a continuing duty. From the moment you file that reissue application, you have to flag any prior or ongoing proceedings involving the patent.
And what kind of proceedings are we talking about?
Well, the MPP lists them out. Interferences, any trials before the TTTAB, the Patent Trial and Appeal Board, other reissues, reexaminations, and, crucially, court litigations.
Litigations. Okay, let's use an example. Say my patent was challenged in court a couple of years ago. Maybe I even won. Do I still have to bring that up in my reissue application?
Absolutely, yes. Even if you won. The rule isn't just about the outcome, it's about the record.
What do you mean by the record?
The court case generated documents, right? Pleadings, motions, maybe expert reports, and definitely court decisions or orders. You need to submit those relevant documents to the USPTO with your reissue application.
Why? What if the arguments were, weak?
Doesn't matter. The examiner needs to see what issues were raised, what prior art might have been discussed, even if the court ultimately sided with you. There might be findings in there or arguments made that impact how the claim should be interpreted or examined now.
Huh. So even old battles have to be rehashed, essentially.
You got it. And it's not just old battles. The duty is continuous.
Continuous, meaning?
Meaning it lasts from the day you file the reissue until it either issues as a corrected patent or you abandon the application. If a new lawsuit gets filed tomorrow while your reissue is pending, boom, you have to update the office.
Wow, okay, that's a significant ongoing burden. Does this connect to rules in other places, like at the PT?
It does, yeah. It mirrors the kind of notice requirements you see in board proceedings.
Yeah.
For instance, at a PTA appeal, parties generally have to tell the board about any other court cases or administrative actions that could affect or be affected by the appeal.
So the USPTO really wants all related actions kind of linked up.
Exactly. They want consistency. Sometimes they might even merge a reissue application with, say, an ex parte reexamination of the same patent to handle them together. Avoids completing outcomes.
Okay, that covers the legal history part, the proceedings. What's the second major obligation under 1418? It mentioned information known to be material to patentability.
Right. This is the broader duty of disclosure that, frankly, applies to all patent applications, not just reissues. It's governed by Rule 37, CFR 1.56.
The duty of candor and good faith.
That's the one. Yeah. Everyone involved has to disclose information they know is material to patentability.
Now, for a reissue, does this mean I have to, dig up every single reference the original examiner cited years ago and submit it all again? That seems redundant.
Good question. No, thankfully. The rule explicitly says you don't need to resubmit everything that was already considered in the original patents file.
Okay, phew.
But, and this is the key part, you absolutely must submit any new information that's material to the claims you're asking the office to re-examine now.
What counts as new material? Give me some examples.
Sure. It could be a journal article that just got published that calls one of your key assumptions into question. Or maybe some prior art from another country that wasn't found during the initial examination.
Or maybe something from one of those court cases we talked about.
Definitely. If a court recently issued a decision, even in a different case involving different parties, but it construed a claim term in a way that impacts your claims being reissued, that's likely material. You need to tell the examiner.
And the consequences for not disclosing something material, they're severe, right? We're talking inequitable conduct.
Potentially, yes. That's the ultimate risk. The entire patent could be held unenforceable if it's found that someone intentionally withheld material information with deceptive intent. The USPTO takes this very seriously.
Who exactly carries this burden? Is it just the inventor signing the oath?
Nope, it's much wider. It's every individual associated with filing and prosecuting the reissue application.
So the applicant, the inventor.
Yes, but also the patent attorney or agent handling the case. Even others who might have substantive input.
So basically, anyone touching the application has this duty.
Pretty much. And remember, under the general rules of practice, just signing and submitting any paper to the USPTO acts as a certification that everything is, truthful and complete to the best of your knowledge.
Like an implicit oath with every submission.
Exactly. And violations can lead to sanctions or disciplinary actions, whether you're a registered practitioner or not.
Okay, so how do people actually comply? How do they package up all this information, the court documents, the new prior art?
That's where the Information Disclosure Statement, or IDS, comes in. It's the standard form and procedure under Rules 1.97 and 1.98.
The IDS. Notoriously specific rules there.
Extremely specific. You have to follow the timing requirements, pay any necessary fees, sometimes provide explanations or translations if you mess up the IDS procedure.
What happens?
Well, the office might just place the non-compliant IDS in the file, but the examiner won't consider the information. They'll note it wasn't properly submitted.
Wait, so you could submit the critical prior art, but if you mess up the form, the examiner ignores it. And you might still have failed your duty of disclosure.
That's the danger. You haven't ensured the examiner actually considered it. It's a huge trap for the unwary.
That sounds like a nightmare scenario. Let's talk timing for the IDS and a reissue. Is there a specific window?
Yes. Generally, you have 3 months from filing the reissue application to submit an IDS without needing extra statements or fees.
But I sense a but coming.
Well, the office really encourages you to file it much earlier if possible.
Why the rush?
It ties back to transparency. When a reissue application is filed, the USPTO publishes a notice to the public. This starts a 2-month period mentioned in MPEP 1441 where the file is open.
So if you file the IDS early.
Then that information, the new prior art or the court documents, becomes publicly available during that 2-month window. Competitors or other interested parties can see what's being considered.
Okay, that makes sense. And the examiners themselves, do they remind applicants about these duties?
They often do. Examiners can include standard form paragraphs in their office actions. For example, paragraph 14.1110 is one that specifically reminds applicants about the dual duty under 1418, disclose the proceedings and disclose the material information.
So it's reinforced during prosecution. Now, you mentioned competitors seeing the information during that notice period. This brings up something interesting about who else can submit information.
Yes, and this is a really key distinction for reissue applications.
What is it?
Think about a regular new patent application being examined. If a third party, say a competitor, finds some really strong prior art they think the examiner missed, they usually can submit it.
Through a third-party pre-issuance submission, right?
Exactly, under 35 U.S.C. 122E and Rule 1.290. But, and here's the twist, those rules generally don't apply to reissue applications.
Hold on. So if I'm that competitor and I know this patent being reissued is invalid based on art the applicant hasn't submitted, I can't just send it to the examiner.
Not through that standard third-party submission process, no. It's generally blocked for reissues.
Wow. That really changes the dynamic, doesn't it?
It absolutely does. It makes the applicant's duty under MPEP 1418 incredibly important.
Because there's no official channel for outsiders to point out missing information.
Right. The office is basically relying almost entirely on the applicant's own candor and diligence to bring all relevant information forward during a reissue. The applicant's disclosure is the primary, sometimes only, way for that external material to get before the examiner.
That puts a massive weight on the patent owner. It's like the USPTO is saying, look, we're shutting the door to outside tips for this process, so you better tell us everything.
That's a perfect way to put it. MPEP 1418 isn't just a suggestion. It's a comprehensive, non-negotiable requirement to provide that complete history, legal, technical, everything. So the reissued patent is examined with full context.
It really underscores the seriousness of seeking a reissue. Okay, one final thought as we wrap up. We've talked a lot about the information the applicant provides. What about the things the examiner writes in the file, like their reasons for allowing the patent?
Yes, the examiner's statement of reasons for allowance. That's part of the file history, of course.
Does that statement lock the patent owner into a certain interpretation later on, like their own arguments might? Does it create a estoppel?
That's a really critical distinction, especially when you're analyzing a file wrapper later, maybe during litigation. The general principle, often drawn from case law, is that the examiner's statement is their personal opinion. And because it's the examiner's opinion, it should generally not create an estoppel against the patent owner. Estoppel, that legal concept where you're barred from arguing something later because you said the opposite earlier, should really only arise from the applicant's own statements and arguments made during prosecution.
So it's what you, the applicant, or your attorney say that binds you, not necessarily what the examiner wrote about why they allowed the claims.
Exactly. It highlights why the applicant's own disclosures and arguments, mandated by rules like 1418, are so foundational. The record you build is what primarily defines the patent's scope and enforceability down the road.
That's a fantastic point to end on the enduring impact of what you disclose. This has been a great deep dive into MPEP Section 1418, and a huge thank you, as always, to Mike Shepard, the creative director behind this whole series.
Absolutely. And just the standard reminder for everyone listening, this summary was put together using AI tools. It's for educational and informational purposes only. It's not legal advice.
Definitely. For the official word, always go to the official MPEP itself or consult with a qualified patent practitioner.
Couldn't agree more.
Thanks for joining us on the deep dive. We'll catch you next time.